do mine first. I met with Mr. Knox on 2 occasions, and Lila Boucher, that's spelled correctly. I've met with Mark Leslie, and Lynn and Rob Blumauer, and Mike Roncivelli, okay. I think that's everybody, I believe.
I've got a disclosure as well on that.
Okay. Mr. Lober?
All right. On February 1st, I and some of my staff met with Mr. Knox as well as Mike, which you said, who were obviously advocating to approve this. On February 5th, my staff fielded a call from a neighborhood resident, Lynn Bloomer, who was concerned about this. And then on February 6th, my staff received a call from a resident named Mark Leslie, who was concerned about this. And then I believe there may have been prior disclosures the last time this was on the agenda.
Correct.
And I have all my disclosures in there, so at the risk of not messing up their last names, letting y'all know they're all in there.
Well, I have to mention the fact that I've met with Scott Knox, Mike Roncivelli, Lila Boucher, Mark Leslie, Shirley Leslie, Lynn Blumauer, Rob Blumauer, Ginger Knox, and Henry Minaboo.
All right. Okay, so we'll let Mr. Knox go first.
Scott Knox, I'm representing Journey Pure. They are the contract vendee for this property. My address is 1900 West New Haven in Melbourne. I'd like to start out by talking about the legal issues, and for the benefit of the people in the audience who didn't get to attend the sessions with the commissioners that I've had, I'll go through that very briefly. I know you've all seen it, but I'd like to recreate it. Commissioner Tobias didn't get a chance to see it, so I would like to go through and do a quick recreation of that. And hopefully, there we go, okay. The first slide that I'm showing you here is a picture of the property in question. You all know where it is, located at the where Otter Creek and Old Dixie Highway is located, and it fronts on US 1. This is a aerial photograph taken in 2008. If you'll notice, the only entrance to the property is right here. So I'm going to move forward now to a photograph in 2010, and you'll see nothing has changed. There's no access to US 1. The only access is right here. And again, I'm going to move forward to 2017. Again, there's no access on US 1. There's only access right here. And one more time, we'll move forward to the property appraiser's map, which I have a blow up here, shows the same access point, and again, no access anywhere on US 1. Now, the reason that is important is because at the last LPA meeting, the issue came up as to whether there was a change of use involved here, which I'll talk about a little bit later. There's really 2 issues in this case: whether the current zoning allows a treatment recovery facility, which it does, in my opinion, and whether or not there is a necessity to come before this board to change use, which there is not, in my opinion. But we'll talk about the first issue first. The reason these aerials are important, the reason that is because they show no change in access, no change in road conditions, no change in road locations. And the reason that is important is because back in when this property was rezoned, and as well as today, this property has to meet the conditions of the comprehensive plan. The main one being involved in this case is policy 2.17 of the land use element. And in 2000, I went back to look at the 2009 rezoning on this piece of property, because it occurred to me at the LPA meeting when this issue of the use came up that the property was rezoned to INH back at that point in time, so that the property had to meet all the conditions of the comprehensive plan. Policy 2.17 of the comp plan was the one that was at issue back then as well. It's the same exact policy today as it was back then. Nothing's changed on this piece of property ever. The access has always been the same. So what I have in front of you right here is the policy 2.17 as it is reported in the staff report from 2009. Now I'm going to focus in on the part that's underlined down there. The policy at issue in this case is the high-density institutional use policy portion of that 2.17. And if you look at it, it says that the property has to be permitted in the community commercial land use designation with access to a road classified as an arterial or higher. So the staff today says that that policy is not met because there's no direct access to an arterial. There's also no direct access to a collector, according to staff. However, when I went back and looked at the 2009 policy, which is what your staff report, which you're looking at right now, the staff, you'll note, where the underlined red is, said the site has access to U.S. Highway 1, a principal highway. So it met the policy in 2009. Today, the staff says it does not meet that policy. In order to rezone the property to INH back in 2009, it had to meet the policy. So the staff interpretation today cannot be correct because nothing has changed. There's no change in policy, no change in conditions. Back in 2009, it met the policy. Today, they claim it doesn't. It can't happen that way. The next thing I came up with in the 2009 staff condition report, and this is another page from that report, confirms what I just said, because the staff was aware it was not an issue of direct access back in 2017. Today, the staff says you have to have direct access to a collector or direct access to an arterial. In the 2009 report, here's what the staff said about this property. Overall accessibility to the site has frontage on US 1, Old Dixie Highway, and Otter Creek Lane. However, due to the proximity of the Bonita Causeway and US Highway 1 interchange, direct access to US Highway is not permitted. Instead, access is available via Old Dixie Highway and Otter Creek Lane to US Highway 1. So looking back at their conclusions about the high-density institutional uses policy requiring access to an arterial, using that description of what the access actually was, it didn't have direct access to US 1, didn't have direct access to any arterial or collector. They said it did have access to an arterial back in 2009 that met the policy because they did not construe it to mean that you had to have direct access. It just means you had to be able to get to US 1. So the staff report, as I read today's staff report, saying this is a non-conforming situation is not correct, because back in 2009, when they rezoned the property, they had to have access to an arterial, and they did, according to staff. Now, I'd like to go into a little bit about the binding development plan, which is the second issue, the issue that came up at the LPA. At the LPA meeting, I'll take you back a little bit. When my clients first came before you, they presented you with a binding development plan, which is basically the very same binding development plan that was passed back in 2009 with one addition. We tried to add the word forcible here. So this is one that applied to Happy Landings. It applied to a dormitory for women and children. And they were under the impression at that time that they were allowed to go forward with a treatment facility under this very binding development plan. But all they wanted to do is change one word in this binding development plan. I've been informed by Dr. Roncis Valley that the folks that came up here to do their due diligence before they moved on this property and put a contract on it were informed by staff, and I can't tell you who that was because I don't know who it was, that this BDP would allow them to go forward with a treatment facility, and they moved on that basis. We got before this board, we get sent back to the LPA. The LPA has looked at it again, and all this really, I've concluded, is completely irrelevant because, in my view, I can't find anything in this BDP that says this property is restricted to use as a dormitory with women and children. Nowhere does it say that in here. It says in the recitals that the property owner of the Happy Landings Inc. wanted to maintain the property as a dormitory for women and children as one of their uses. It says, whereas they wanted to do that, these following conditions apply. And there was 5 or 6 conditions laid out in the BDP that they had to conform with. In fact, at page 3 of the BDP, in paragraph 11, which I know you have that in your materials somewhere, but it's hidden deep in your materials, I'm sure. It says that this agreement shall be binding and shall inure to the benefit of the successors or signs of the parties and shall run with the subject property unless or until rezoned, and shall be binding upon any person, firm, or corporation who may become the successor in interest directly or indirectly to the subject property, and be subject to the above referenced conditions as approved by the Board of County Commissioners on September 3rd, 2005, which is the prior BDP, which was incorporated into this one. In the event the subject property is annexed into a municipality and rezoned, it's null and void. So what we're referring to in this document was conditions that applied to that use of a dormitory for women and children. It does not say that every other use that's listed in the INH zoning is precluded. It does not say that anywhere in here. The county knows how to say that. I've talked to staff. The staff even told me, yeah, we know how to do that. What we do is we say you can do A, B, C, D, and E, but you can't do the rest of the ones in INH. Or we say you can do all the INH zonings on this piece of property, but you can't do B, C, D, and E. But we don't say, we just don't leave it hanging and say this property, because it says, it mentions a dormitory for women and children, just because it says that somewhere in the document, but not in the conditions. There's no word in here that says it's limited or restricted to that use. And just because it says that in the document doesn't mean that every other use is precluded for the remainder of the existence of this BDP, which could be forever. That doesn't make any sense. Somebody coming before you asking for a limited use to one use without any possibility of future use would be crazy. And I don't think that's what happened in this case. So from our point of view, this property is properly zoned for a treatment and recovery facility. It is a permitted use with conditions. The conditions are set forth in the ordinance, and the conditions have to be met when it's time for a site plan to be presented to the county. There's certain things they have to do, have to show, that will govern how many people they can have in this facility, will govern how many parking spaces they have to have in this facility, it will govern how big the buildings could be in this facility. But that's all those conditions have to be shown on your site plan, and that will determine how this property gets used. But it is permitted if those conditions are met. And they have the opportunity to go forward and meet those conditions. And we don't think this binding site, this development plan has any has any relevance whatsoever at this point. And as I said, it's our belief that this property is permitted, is a zoned INH. It does permit a treatment facility with conditions. And with that, I'll defer to Mr. Roncesvalles, who has a short presentation on the type of uses that you're going to see on this property.
I believe so. Yeah.
Good evening.
Hi, can I have your name and address, please?
My name is Mike Roncesvalles, 1299 Bedford Drive, Suite A, Melbourne, Florida, 32940. I'm going to tell you a little bit about who we are, just so you can understand what we're proposing for the property. I want to start with just the need that we have sitting before us as a community. Brevard County needs a facility where professionals can provide effective treatment for substance abuse simply because we're faced with a crisis. We've got to... What's that?
Can you full screen that? I'm sorry, it's just hard to see.
Man, you're all right. I'm sorry.
Thank you.
I forgot to start my slideshow.
Thanks.
There we go. So we have a crisis before us as a community. It takes one click on yahoo.com or one TV news show to say the opiate problem that we're facing is significant as a country. I want to tell you just how difficult it is, how immense this problem is. If you look at this graph, this is 2017. We had 72,000 Americans die from drug overdoses. If you look back at 2013, there's about 40,000. That's an uptick of 30,000 people that have died nationally every year. I teased it out for you a little bit so you can see what our problems are. We're having a problem with all drugs and alcohol, but the biggest issue is the synthetic opioids. I think we all know that. Now, it's a big problem. It's a national problem, but for us in Brevard, it's very local. Here's a list of the top 5 counties in Florida with the most drug or alcohol overdoses from 2014 to 2016. You got Palm Beach, that's not really a surprise. Number 2, Brevard County. Can you believe that? All the metro areas we've got all across this state, Brevard County had 1,032 people die. People living in Brevard County were 44% more likely to die due to drug overdose than an average American. So we've got an issue that we want to provide a solution for here in Brevard County. Nationally, there's about 1.3 million people who seek treatment every year. There's a lot more people that need to seek treatment, but about 1.3 people actually seek treatment. 6 months after they get treatment, 60 to 80% have relapsed. These are not good numbers. It's unbelievable. I'm excited to be a part of the Journey Pure family because we're doing this differently and our outcomes are significantly better, and we can demonstrate this. We're tracking all of our clients and our patients and how they do as they work through our treatment. Based on our numbers, we've almost flipped the tables from most other rehabs. For us, for people that start our treatment, a year out after treatment, almost 70% of our patients are clean and sober. So a lot of people ask, how do you do that? What are you doing differently? Well, we start by addressing mental health and substance abuse in conjunction. Like we're truly a dual diagnosis treatment facility, and we use evidence-based programming. So we start with an assessment. I'm going to tell you a little bit more about that going forward. We individualize our treatment plans for each individual, and then we integrate a technology-based coaching program, which I believe is one of the most impressive things that we do as a company. Is we follow people long after they leave us. We're following them on their cell phones. They're communicating with us. We're prompting them to do healthy things, and they can reach out to a coach at any moment that they feel triggered or relapse. I'll tell you more about that assessment piece because
You have about a minute left.
all right.
I'm sorry.
That's okay. We have professionals that are doing this. They're giving thorough physical evaluations, mental health evaluations. But I want to really end with what we're not. And what we're not is a recovery house. We're not a sober living community. We're not a community mental health center that admits Baker Acts or court-mandated treatments. We're a group of professionals that are working together. So as medical doctors, psychologists, licensed clinical social workers, licensed mental health counselors, working together to help affect change in people's lives and to help them get clean and sober and stay clean and sober over time.
Great. I'd like to go through the cards first, because there's a lot of cards, and then we'll call you back up, I'm sure, and you'll get a chance to rebut. Okay, I have Mark Leslie, and after Mark, we'll have Ellen Montgomery.
Mark Leslie, 2665 Hilltop Lane, Melbourne, Florida. Some interesting information about the previous binding development plan. It was my understanding from discussions with Lila Boucher, who is the current owner, that Mr. Knox wrote that plan for her. So I'm not sure why staff is getting blamed for some of the whereases not being in the right place. But I'm going to go through this binding development plan that they're providing. And I'm going to read to you the parts that are in red, leaving you to read what's already in there that you hopefully have had a chance to look at. The first section there, developer does not own, or the owner signing as developer. Who is actually applying here? Is it the owner or is it the developer? The next one, does not bind the owner of Happy Landing Homes or the property or anything to anything. This particular plan doesn't. I'd like to know what DOC stands for. It's difficult to make out all of the language in this document. Does it mean doctor or doc? Maybe Department of Corrections, we don't know for sure. It needs to be spelled out. And pursuant to what in 62-1157? That's the rules for binding development plan. We don't really know what that means. The next whereas, abutting landowners is not neighborhood or neighbors. It's their property. It's interesting that the incorporation of recitals by reference herein was not included in the owner's previous BDPs from 2005 and 2009, but they are now. It does not say the developer is responsible for the construction of any improvements, only maintenance of improvements. If you look through that, it references all kinds of stuff that the county doesn't have to maintain or construct, but they only have to maintain. They don't have to construct anything. Ask the developer if this means construct new facilities to meet facility standards enumerated in 62-1126, 3, and 5 for this medical facility. That is the square footage standards and the parking standards. Okay, B. Currently, it's not maintained, and they are in a non-compliant status. I did do a public record search. There are several of the items that never happened. Inspections that were supposed to happen by the county have not happened. There's a list. I don't have time to go through too much there. It does not meet the requirements of code to connect arterial or arterial collector. I'm going to skip on down to D because it's one of the biggest ones. Reference to code 62-1862-3 does not exist and is not enforceable in law. That number 62-1862 should be 1826. And he uses that number 3 times in this particular area, and he discusses all of the square footage requirements there. The property appraiser's webpage is incorrect. He references that as their square footage marker. The aerials he showed earlier show a building that was there and now it is not there. They're still claiming that in the property appraiser's records. They really have about 5,500 square feet, not 90-something. That building was removed because it was illegally constructed and placed in there. A footprint is not a building. The existing facilities need to be ground truths by staff as the applicant is not being straightforward in their assessment of the existing structures. Ask if this section means the applicant shall comply with the facility standards set forth in 62-1826, section 3. It says shall limit occupancy of buildings on site to 68 residents and staff. Square footage on site is roughly 5,500 square feet. Ask if this means the applicant shall meet the facility standards set forth in 1826-3, or if they plan to limit the occupancy of the current buildings to 47 and 21. Assigned resident is defined in code and contains the correct language. Item F falls short of that definition for both residents and staff. Ask staff what the actual definition is, please. Jail or prison for patients. What does DOC stand for? Doctor, Department of Corrections, patients from the jail? Brevard County is an agency with jurisdiction. Does this infer that the developer does not have to meet 250 square foot floor space per assigned resident as described in section 1826-3-1A? He seemed to leave that little number out, which is very significant. What precisely are the agencies with jurisdiction? What about the 250 square feet per assigned resident?
Mark?
Yes.
Your time.
Is there a chance I could get a motion for just a few more? I spent a lot of
Then
time
I
on
have to
this.
let everybody do it. I mean, you could designate
Well,
what you
you have the questions in front of you in red.
Right,
Please.
and I'm sure a lot of people have read your emails and.
This
like
is
a
not
lot
in any emails or anything. This
I know,
is new
but we're
stuff.
just getting this now, so.
understand.
And I appreciate that, but you can't give him your time, but you can speak, and talk. I mean, if you had another 30 seconds or something and wrap it up, that would be fine, but.
Could I get a motion for that and I'll knock it out?
Sure, go ahead.
Okay,
I'll give you another minute.
thank you. I'm going to jump to
Anybody else that wants one, just ask, to be fair.
item H. Brevard County is an agency with jurisdiction. Does this infer that the developer does not have to meet the 250 square feet? Ask if this means the applicant will have built the facility that meets all of the facility standards set forth in section 62-1826-3 within 1 year of receiving a permit from Brevard County to construct a facility that meets the standards of 62-1826. Developer does not represent adequate parking spaces available for future use once facilities are expanded to meet square footage requirements in 1826-3, which they have not agreed to in this document. Existing parking that is currently used and available will not be adequate. That's what they're saying they're going to use. With the exception of unenforceable item D, suggests they will never comply with 62-1826-3. Why would the developer, not the owner, need to be currently in compliance with any provision of code for which they are not bound? The actual
Okay,
owner
Mark.
is not currently. Thank
I'm
you.
sorry. Thank you. Who's next? Ellen Montgomery, and after Ellen, Shirley Leslie. Maybe Shirley Leslie can read the rest.
Ellen Montgomery, 2695 Pinecone Drive. I live in the neighborhood. Definitely not opposed to what this gentleman said before about what their facility would offer, because I do feel that that's a very fine things to offer for the needs of the people who have these concerns. But in a small little neighborhood like ours, it's very difficult to think of the traffic that's going to come in there or go out of there. Now, they did say that it stayed the same all these years, whatever was there. But the last facility that was there with the women and the children, the women did not have vehicles. They came and went with the concerns with maybe some kind of transportation given to them or something like that. They were from poor backgrounds or whatever. They didn't have the means to do that. And so there was not a lot of traffic. And right now, this evening, with my husband trying to get out onto US 1 to come here this evening, he had to wait for our grandchildren to go home. It took him 5 minutes to wait to get out on the highway, on US 1, from that one way of getting out of our little neighborhood. And you all know what's going on with that US 1 now, with the grills right around the corner and so on, people coming in and going out and so on. And there have been 2 deaths at that corner in the past, and that was before we had all this traffic. So would we be needing a light there for all the traffic that's going to be possibly coming into our neighborhood from this facility? I also have my 2 grandchildren that like to ride their bikes in that neighborhood, and I'm concerned about them, you know, maybe running into vehicles or whatever. They like to go down and see the peacocks at the sanctuary. So, I mean, it's a concern for us as neighbors for the amount of traffic coming in and out. And as far as the facility that it has to offer good things for people, I don't have any question about that. Thank you.
Thank you, Ms. Montgomery. Shirley Leslie, and then Kevin D. Lee. For us? Okay.
Okay. Shirley Leslie, 2665 Hilltop Lane. And I'm here to remind you that we're here to request an amendment to the existing BDP that's already gone through P&Z, not an old BDP or another BDP. And the amended BDP for Happy Landing Homes, not for Journey Pure, has too many errors, inconsistencies, and misleading representations for the board to even approve it. A BDP is a legally binding document, but recitals usually are not. Please assure whether these recitals are or not legally binding. The developer does not represent and warrant that he is the owner, which must show markable title or certification of the property. All throughout the BDP it says the developer shall. There is no guarantee that this developer will become the owner. The BDP references compliance to Section 62-1862, like Mark said. There is no 1862, and the BDP can be unenforceable due to a unilateral or mutual mistake, and the court would have the right of rescission or reformation, the courts. The property will offer services more intensive than those required for rooms, board, personal service, and general nursing care, and offers facilities for beds for use beyond 24 hours by individuals requiring diagnosis, treatment, and care. Florida statute says these services qualify a facility to be a hospital, which would move this facility into a higher intensity use. The BDP says patients in 2 instances and actually flip-flops between residents and patients. The BDP says there are over 9,000 square feet of building footprint. There was actually 5,600, less than 5,600 square feet. The BDP says semi-annual meetings with the neighbors shall be established. Doesn't say that they'll be held, only established. The owners did not hold these meetings either. County inspections are proposed. Inspections have never been conducted. There is no county control or oversight of facilities like this. No rights and protections of health, safety, and welfare as required by this county's zoning are afforded the citizens of this county. Conditions precedence means all conditions shall be met, but the BDP seeks to circumvent the requirements to meet square footage requirements. History has proven that certain elements of the existing BDP were not adhered to. There's no guarantee the developer owner will ever meet the existing will ever meet the square footage standards enumerated in 1826. The same facility standards for square footage have applied to this property since it was rezoned in 1986, and they have never been met. The developer shall comply with certain facility square footage standards of 62-1826 within 1 year after receiving approval. Florida Administrative Code 65D30 says a license must be provided. Licensed facilities used by a provider shall comply with health and zoning codes enforced at the local level, your level, and all providers shall update and have proof of compliance with local fire and safety and health inspections annually. In addition, the owner must possess a business tax receipt prior to commencement. The developer offers to make criminal background checks available with 30 days of recordation and therefore upon request of the county. Okay, who in the county is going to make these requests, and what tool do you have to continually make these requests or assure these background checks are available, remembering that both the staff and residents continually change? Also, the BDP wants to allow convicts whose sentences were suspended, probably because of a plea bargain. The developer operating the center will not contract with DOC. Well, what about the owner or other employees of the center? Would they contract with DOC possibly? Maybe. The BDP does not truly represent that parking requirements, including paving, are met. The BDP says violations of the agreement may be enforced by. It should read shall. And of course, Otter Lane is not Otter Lane, it's Otter Creek Lane.
I'm going to give you another minute.
Thank you. The conceptual graphic representation is of a facility not approved by or located in Brevard County, and the actual square footage of the property's facilities is incorrectly represented in both the BDP and the county's property appraiser's office records. This section references the foregoing minimum code requirements in section 62-1862-3, again, which does not exist. Poorly written document. The owner is shown on the signature page to be the developer. Poorly written document. Since the property and some activities are visible from the crown of Old Dixie Highway, an 8 to 10-foot fence would be more appropriate, as you can see stuff. Also, the existing fence is in disarray, and the developer could possibly assume that fence to be adequate. Thank you.
Thank you. Yeah, and I'll let the applicant have a little bit more time too, since it's fair, if you want it. Kevin D. Lee, and after Kevin, Lynn Blumauer.
Kevin is with us.
Okay, you can speak now, or
Okay.
whichever you like. I try to go in order as when they're handed in, so if you don't submit them together, oftentimes you get put in the middle.
My name is Kevin Lee. I am, address is 624 Grassmere Park Road, Nashville, Tennessee, and I serve as the CEO of Journey Pure. I want to make a few comments. We've got the slides going. Can you guys see them? Journey Pure serves over 200 folks per day in Kentucky, Tennessee, Central Florida, and in the Panhandle of Florida, who live in residences like what we want to develop at the Happy Landings property. We get really, really good results. Our patients come to us because they want to. They're voluntary. They're not court mandated. They're not required to be there. Other than they want to get healthy. So they're sober. They don't feel good a lot of times when we get them. The first few days it may not be sober. You could argue that. But anyway, we get really good outcomes, and as a result, as you can see on the charts, up there, 84% of our patients report not having abused substances 6 months after they get treatment with us. Therefore, the insurance companies like what we're doing. We have every major managed care contract we want. Florida Blue, for example, Cigna, Aetna, those people work with us. We get more and more folks referred to us every week from Ford Motor Company, Chrysler Corporation, and so forth. There are 11 residential facilities, the way you could count, in our system right now, and I would know if we were having problems with the neighbors. We're viewed as being a good neighbor. In fact, our Murfreesboro, Tennessee facility, just outside just outside Nashville, has been there for 3 years, and we just have a neighbor completing a new house, very nice house, right at the end of our driveway. I don't think they'd do that if they thought they would get into a problem situation. So, a few pictures of our facilities. These are examples. We build them out nice. We have to comply with codes everywhere we are. The Florida Department of Children and Families would license this facility. We have in Florida right now 6 facilities licensed by the Florida Department of Children and Families. So just some example pictures. So we fix it nice. Somebody made a comment about the parking. We'll build parking spaces to accommodate, make it comply. That's in Panama City Beach, their facility on Highway 98. And that's in Jensen Beach, Florida, south of here. And just some examples of residences we have. And they're all in neighborhoods similar to what we're contemplating here. Okay. That's it. That's all I've got to say. Thank you.
Okay. All right, Lynn Blumauer and Ginger Knox.
Hello, Lynn Blumauer. I own the property across the street from the proposed medical facility, 5920 Old Dixie Highway. I'm here today to ask again for your help in our quest to protect our property values and the general safety and welfare of our neighborhood. We understand the need for these types of medical facilities and are sympathetic to those in need, but believe a residential neighborhood is not the place for them. Without security and legal means to keep patients on site, the neighborhood will suffer consequences once again, as the ingress and egress would be in the neighborhood, not an arterial road. The proposed use will cause a substantial diminution in value of the neighborhood. The applicant is seeking an amendment to the existing BDP for the purpose of expanding the service to include men, felons, and develop the property as a residential detox and treatment facility. Currently, it is a dormitory for homeless women and children. The change of use would be an expansion that is less restrictive. It is a completely different business. It's a medical facility that does not fit in any residential neighborhood. Pursuant to Section 62-1157, conditions proposed within a binding development plan should be more restrictive and cannot be used as a tool to circumvent existing code provisions. Section 62-1103, interpretation conflicting provisions. The provisions of this article shall be held to a minimum requirements adopted for the promotion of the general public health, safety, and welfare of the people of the county. In the event of conflicting provisions, the more restrictive provisions of this article or any other regulations adopted by the county shall apply. Location standards. The increase of traffic from residents, staff, visiting family, doctors, ambulances, and other services will change the impact of the neighborhood as the ingress-egress is in the neighborhood, with a narrow blind corner and no sidewalks. Children will have to pass by twice a day to catch the bus and return home, possibly during employee shift changes. This is a safety issue. Since 2009 and the inception of the INH zoning, there has been little impact on the surrounding neighborhood, as it appeared to be abandoned and is currently in a state of disrepair. Even to its full potential, which never happened, a dormitory for homeless women and children would have much less impact, as most did not have vehicles, and only a handful of women and children have ever been there. There have never been 47 residents here. Regardless, there is only square footage to accommodate 14 people. The on-site sewage is another issue. Section 4666, on-site sewage disposal system in a commercial, manufacturing, and industrial area. No initial or annual or temporary business tax receipt shall be issued by the county tax collector for any business or occupation for any property within the county located in a commercial land use classification, where such business location, profession, or occupation on the property is served by on-site sewage treatment disposal system until such application for the initial, annual, or temporary business tax receipt has been reviewed and approved by the County Office of Natural Resource Management and the County Health Department's Environmental Health Service section. A binding development plan is a tool for an applicant to agree to conditions above and beyond code criteria. Conditions within a BDP should not be utilized as a mechanism to waive existing code provisions. The conditions in the BDP are essentially become part of the zoning action, so as they are enforceable by code. But unlike the health department, there isn't a schedule for inspections, so unless there is an incident or complaint, no one would know. In the words of Ron Bratcher on the P&Z board, it's like sending the fox into the hen house to see if there are any foxes in the hen house. A BDP is essentially worthless, as the existing one was not enforced. No meetings, no inspection, no compliance. What is there to protect the neighborhood if there is no enforcement? The current BDP states that any violation of the agreement will constitute as a violation of the zoning classification. In times of controversy, I put myself in the other position. Think of your grandparents, your parents, your son, daughter, and their family living in the neighborhood. Would you feel that they would be safe and their property value not affected? I think most educated people would not. As judge and jury of this quasi-judicial hearing, regardless of past use or history, approving this would have an injurious effect on the neighborhood, and the county is bound by code to deny. Any questions? No?
Change your notes?
Hi. Okay, Ginger Knox, 2720 Pinecone Drive, Melbourne, right there in that neighborhood. Before I start, I did a PowerPoint, so I don't know who has that. They said they uploaded it. But before I start my PowerPoint, I want to clarify that we're actually talking about the same BDP I thought we were coming here to talk about? Because it kind of sounded like Scott said he doesn't need a BDP to do this. So I just want to clarify before I go into 21 slides about how horrible his BDP is, that we're even still talking about that BDP.
I mean, I can respond.
Okay?
I mean, you can. I guess it's a little unprecedented, but that's fine.
The short answer is, I don't think we need a BDP to do what we want to do.
Because
They
you're
apparently
thinking you
don't-
can operate off the existing BDP.
I don't think that BDP is even relevant at this point. I think it's a permitted use with conditions. If we meet the conditions, we get the permit. You don't need to do a BDP. They apparently are not happy with the BDP that was presented, and, at this point, I don't think we need it.
Okay.
So
I will not tell you what to talk about, but
Okay.
I'll tell you addressing that the new or the most recent BDP is probably pointless at this point if that's not what the applicant
That's
is
what I'm
wanting to do.
thinking too. I have lots of pictures,
Just
and I
a
spent 2
suggestion.
days on this PowerPoint, but that's fine. But let me just tell you, I was there in 2005 when we did the BDP that he's referring to isn't legal. He was actually the county attorney, so how he could ever have a BDP that's coming through that's not enforceable and then stand up here and tell you it was awful that the county approved it and it's not enforceable? I guess that's for attorneys to fight about later, but I think it's a conflict of interest. I spent months and months of my life with the people who were at Happy Landings Homes to come up with the 2005 BDP so that they could continue doing good work for people in our community. Because even though they were doing things illegally there in 2005, we as a community thought that it was important work, that because they could do it with a little impact on traffic because they were going to go by that BDP that they had, that we could all work together as a community and make that happen even though they weren't on an arterial road. Now I do want to say in 2009, us as a community, if you look back, we weren't involved in 2009. We didn't even know they were going to a higher intensity. We were left out of that entirely, even though we were a large part of the 2005 rezoning. So whatever happened in 2005 from 2009 from 2005 really didn't have any of our input. Now, of course, I will say that it was going smoothly. There wasn't any, people having sex in our front yards at that point, so we weren't really involved on a daily basis like we were in 2005, and we will be again if we have a corporation that wants to come in and not have any square footage requirements, parking requirements, bathroom requirements for their residents, all these things that they put in front of you, which are absurd, and that's why they withdrew them before today's meeting, because we all know you can't even approve those things. You can't tell 47 people they can go to the bathroom in 4 bathrooms because Mr. Knox wants it to be okay. It wasn't legal. The BDP they were bringing to you today wasn't legal. That's why they withdrew it. How we can even now completely throw out the fact that they need a BDP for a medical detox center in a residential neighborhood, not coming off the right road, with 47 patients when they've only ever had room for 14 patients. I mean, that's up to you guys to decide. Can you do it here without any background, without us even doing any research? I mean, all the research that we've done is being thrown out at the last minute. We can't tell you guys what to do, but we would say that's not fair to us as a community. That's not fair that they don't have meetings with us, and that when they do have a meeting with us, they say they don't even have to listen to our input because of who their attorney is. I'm saying we are amenable. Okay, we want it to be a good environment for everyone, but they don't think they need that. Okay, they think that they can force you because apparently an employee here didn't catch something. He was the attorney and didn't say anything, and now he's their attorney, and then that makes everything okay, and they don't have to go by the right roads now. They don't have to follow any of the right codes because someone overlooked it. He's the someone. You can't say the applicant is okay to not follow the code when the applicant's attorney was the county attorney that made a mistake. I mean, I did a whole PowerPoint presentation. I'm not going to waste your time or mine. I'm going to let it go. But I don't see how you could push this through at the last minute with all this, with all these changes, with no BDP, with no protections to the community at all. Hey, if he wants to keep women and children there and only do the dormitory use with the existing BDP, we're all for it.
Thank you. That's all the cards I have. Do you want to come up and rebut?
If the,
I don't think it matters.
if the folks in the audience had really carefully read the BDP that was presented originally, they would have found out that the conditions that are set forth in this ordinance are tracked in that provision, in that BDP. That was trying to assure them that that's what was going to happen. Since that happened, we have discovered things from 2009 that makes it clear that this is a permitted use with conditions, and if those conditions are met, which are also in the BDP, then we are good to go. All we have to do is present a site plan. We don't really have to go through the BDP process at all. We were doing this now, tonight, we could withdraw tonight and move forward with a site plan is the way I'm looking at it. But if the commission feels that we need to put in some kind of conditions to protect the neighborhood, we're willing to do that. We're not willing just to walk away from the BDP at this point. I know there was some talk about getting direct access to US 1. We can't do that. That was in your staff report. There's some talk about moving the access point to the north of the property. We are willing to do that. There's talk about the felons not being, forcible felons not being permitted as residents. We're willing to do that. We're willing to not hire felons as employees. Those are the things that are in the BDP. There's a lot more to it that track the conditions, but we don't think those are necessary anymore because it's a permitted use with those conditions. Those conditions are in the ordinance. We have to meet those conditions already. And by the way, I don't have a conflict of interest. I have determined that with the Florida Bar by telephone and in writing I have it.
Did you have questions for Mr. Knox?
I have several questions, if that's all right.
But I mean, I would suggest we probably should start with Mr. Knox first.
Yeah, let's start with him, if I may. I have a few questions for you, and some of these are based on the conversation that we had that I referenced in the disclosures with your client, and then also Fritz, I think, was present at the time as well. A few questions. One of the items that was brought up, I'm forgetting the gentleman's name, Mr. Leslie. Thank you. One of the items was talking about a portion of the BDP that was submitted, and I'll just read it in pertinent part to save some time. Item H, basically saying, if not already in compliance on the day of the treatment and recovery facility, and it goes on, basically allowing it to come to compliance within 1 year after receiving approval. It just struck me as something that's atypical, and I'm curious as to why that was included in the BDP.
I cannot recall why that's in there, but we're happy to pull it out of there.
Guys, I appreciate that. And then a few other questions. One of the items that you may recall we discussed when we were sitting down in my office was some of the neighbors' concerns with respect to having folks potentially cause problems in the community. And there was a reference, if I recall correctly, that there's a gate on the facility that's planned, or please, if you would.
Yes, please.
I think one of the conditions that was in the proposed BDP was that we'd had built a fence, which would have an entryway in it.
So is the thought that they would, or the residents or patients, whatever you wish to term them, is the thought that they would be free to come and go, or that they would not be free to come and go?
They're not free to come and go. They're kept on the property for 28 days. That's why they're there.
Well, let me ask you, because again, I saw it, I'm not trying to pull a gotcha on this, I'm just trying to understand what's going on. In the slideshow, and correct me if I'm misrecalling this, there was something indicating that you all wouldn't accept Baker, and I don't remember if Marchman Acts were in there as well. If they're not being involuntarily committed, how are they not free to go?
I assume they have a contract. Yeah.
I'm just really confused with this.
Yeah.
They can leave. Patients can leave.
But they potentially, I guess, forfeit whatever.
They can leave.
Okay.
And if they decide to leave, we'll get them a ride to leave. They're not going to go out walking on the street. They're calling a family member or somebody else to be able to leave.
But they're not coming and going, is what?
No, they're not coming and going. They don't use their own cars to get in and out. The only cars in and out are to bring new patients in or take patients being discharged or completing their treatment away, or employees.
I'm just wondering, partly from the trip count perspective, whether we'd have people either having a more strenuous use of that infrastructure or less strenuous use, but I think that answers it to a degree. And I'll hold the rest for folks later if you want to.
Commissioner Tobias?
Thank you, Madam Chair. And this one's for Mr. Knox. Clearly, you're well-versed in planning and zoning. My basic question is, you think this it's your opinion that this is a permitted use with conditions,
Correct.
and you're okay with the existing BDP,
The existing BDP being the Happy Landings BDP.
the one from 2009?
The only thing, if that were applicable, the only thing we'd want to change is add the word forcible in one location.
Okay, so to be clear, my question was very basic. If you said you could go ahead without being here. My question is, other than, I don't want to say it, billable hours, but why
are we here?
Yeah, why are you here? Dumb it down for me, please.
Because at the LPA meeting, the issue came up as to whether we had to go back before the board to get a change from the use of dormitory with women and children to a treatment facility. I called the staff, I sent an email to the staff after I heard that at the LPA meeting and asked, are you taking the position that this is the only use you can put on this property unless you go back to the board? Their answer was yes. So my view is we don't need to worry about the BDP because it doesn't say it's restricted to that use. So this old BDP doesn't even apply and it's not even relevant. However, should you decide to impose or ask us to impose those conditions on us, we would do that with that one change.
Okay, and this is a bounce to the county attorney, please. Do you have the same opinion that Mr. Knox's clients should we vote down, would they have the ability to move forward with this as a permitted use with conditions with a pre-existing BDP?
Respectfully, I do not agree. I think the contention that the binding development plan is invalid has several problems. You have a document that references, it is not a perfect document, that much I can agree with. It's not perfect. However, it was not adopted in a vacuum. There are minutes, there's board direction. All of that says dormitory. I think you would end up with that evidence before the court, and I think it would be found to be limited to a dormitory use. If you move further down the line of logic, if the binding development plan is not valid, then the zoning may not be valid, and you would revoke the zoning. And then finally, I have the same question Mr. Commissioner Tabaya asked. If he did not believe that this binding development plan is binding, I don't understand why we're here.
I'd be happy to answer that.
Can he respond first?
Yeah, sorry.
Yeah. The reason we're here is because originally my client thought they were allowed to come before this commission with the old binding development plan because they were able to use the treatment and recovery facility under this binding development plan, notwithstanding my respect for Eden's opinion. They were told that. That's why they came before you and came with the same binding development plan that they had that was in existence in 2009 and changed one word because they just didn't want to have to deal with felons as opposed to forcible felons. That has mushroomed into this huge thing, in the course of which I discovered that, in fact, back in 2009, this was approved as a treatment, as a INH zoning, which allows a treatment facility. This document does not restrict the use of this property forever and ever to one use for a dormitory for women and children, period.
So one quick follow-up.
Sure.
So just to be clear, and yeah, I'm clearly not, I'm seated between two bride attorneys, but not one myself. And I have no idea, obviously, Sunshine, this is what makes these meetings fun. I have no idea how this vote goes, but let's assume that you're on the short end of the stick. You press forward anyway.
We'll be back in front of you because I suspect your staff will deny the site plan and we'll have to come back and appeal that to you.
Okay. Thank you.
Or we can do something else too, which I'm not, I
Yeah,
prefer not to.
I understand. I was, yes, thank you. And thank you for not making that threat as many folks do up here. You handled yourself very well. I appreciate it.
Commissioner Lober.
And this is more for Eden, just to kind of dovetail off what was just discussed. The vibe that I was getting from this direction was that, but for the BDP, the first rezoning would not have necessarily even occurred. Is that fairly accurate?
It does appear that that was the restriction to mitigate the negative impacts of putting INH zoning in this location.
So if the BDP were found to be invalid, potentially we'd be revisiting the rezoning that occurred in the past as well?
I would expect so, yes.
And then the last question on that line, with respect to it previously having been permitted as a dorm, with this now being a medical facility, is it your opinion that that's a different variety of use, a potentially more or less onerous variety of use?
Well, I think your code classifies it differently. I mean, you have treatment and recovery facility in your code as opposed to a separate use for dormitory. So they are different types of uses. And I think the question for you is it a different intensity? Will it have a different impact on the neighborhood?
I appreciate it. Maybe we should bounce it to her.
Is that a different classification of use, like, or is intensity of use, dormitory versus treatment facility?
You know, I would say that when the board considered limiting it to just the dormitory within the INH zoning classification, that they perceived that it was a separate intensity of use, which is why they limited the other uses.
But I'm just saying comparing the two, comparing a
intensity, it depends on the level that you're measuring. As far as trip generation, we do not feel like the different uses produce a significant difference in trips, but intensity is measured by a lot of things, not just infrastructure. So if the intensity was the same, then conceivably it would have been a permitted use within the binding development plan when the rezoning was applied. So yes, I believe it is.
Commissioner Smith?
I'd like to ask staff, is this property served by a sewer?
No, this is septic.
Okay, shh.
Well, that's kind of a problem for me, being so close to the river. But I can tell you, aside from that, I spent a lot of time speaking with the applicant and the neighbors and staff. And having done this, I've come to what I think is something that's needed to protect the neighbors and the applicant and the county. I think, first of all, from what I've heard, I'm still not crazy. I'm not going to push this because I just don't want to see this thing without a sewer. I think there's a sewer line that runs down US 1, but I'm not positive. But aside from that, I think if we change the wording to developer/owner, that covers one of the concerns of the neighbors. If we strike 3H, 3I, and 3J, I think that solves a lot of problems with the county and the neighbors. And if we, as I had suggested in our meeting together,
Is this the new one or the old one?
the northern driveway, which exists currently, but it's small, if that was designated as the main ingress and egress, that would eliminate a lot of the traffic that the neighbors are concerned about. And then you could eliminate the existing main entrance.
Say that part again one more time.
There are two entrances on this property. There's a northern entrance, which is very small, but it exists. It's right there. So if
Okay, please.
if cars are coming into this property, they would come down Otter Creek Lane, make the immediate left, and then they would make another immediate left, so that they wouldn't be driving up and down the road. And I think that's doable. And I would also recommend a stop sign at the end of Old Dixie Highway as it approaches Otter Creek Lane, so that people coming and going would have a duty to stop, so that we wouldn't have any traffic mishaps there. And lastly, I think that the community would be well served with a facility like this. But that's what I've got.
I'd like to say something, just to chime in, so I'm not doing it all at the end and not asking questions. You know, I think we went back and forth so much with this, and I read your P&Z minutes, and you are queen for some of what, you know, over the past several months that you've had to deal with. But I don't know how we rectify each and every item. I know some of the concerns with the existing inspections. I mean, I don't know why, and I think, even the county staff now is asking, why would we agree to do inspections when we really don't have the authority to do them? So, I mean, I don't think that that would even be enforceable anyway if we went back to the old BDP.
I think that was done to appease the neighborhood.
It was, but at what authority? And I think we should probably, and maybe that's a question more for the applicant, a little bit more to talk about your licensing and your inspection process, because I'll tell you what, as a new nurse practitioner, it takes me months to get credentialed with insurance companies. And I'm practicing, but I'm still accountable, and I'm registered with the DEA. There's things that I have to go through. I can't imagine you having a facility where there's insurance companies that just approve you just arbitrarily, and you're running some kind of dump. I don't see that as a possibility. Yeah, could you come up if you don't mind?
I'd ask him, yes, Mr. Lee, step up. But I would say this, that in order to get that license to make themselves subject to those regulations that you're talking about, they've got to get the zoning straight first. They've got to be able to go to them and say, we have the zoning to do this.
Right.
Which is where we are.
I just know, and again, you can talk about the process. I know it's not like you're blanket approved and all of a sudden all these insurance companies just start paying you the fee. Okay, yeah, we'll go ahead and approve this service. You have to get approved through each one of them, and then you have to maintain certain standards with the state to be able to get that approval, correct?
We do. Kevin Lee speaking. And thank you for asking that. I'm glad you're familiar with it. All of our facilities, all of our operations are licensed by the state respective departments of mental health, or in Florida, it's Department of Children and Families, and we get routine inspections, surprise surveys. More importantly, I think, all our facilities are accredited by the Commission on Accreditation of Rehabilitation Facilities, and those are pretty high standards. We are a TRICARE contractor, and to be approved by the TRICARE system, that's active military, that's really strenuous. It takes a year. So it's a pretty strenuous process and what we have to meet. The insurance companies require those accreditations, like the Commission on Accreditation of Rehabilitation Facilities, and those licenses, and all of our staff to have licenses as appropriate before we can be contracted with the insurance companies, which I mentioned earlier. We have them all, so they're very supportive of us.
Right,
Okay.
each one of those insurance companies goes through their own process and background and such.
And they make site visits, they come
Yeah.
see us, they audit records and make sure we're keeping charts like we're supposed to and so forth. Yep.
And, regardless of whether or not we approved, I just want to say that, I didn't want that perception that you were just somebody that was just coming in and, able to just throw up a shingle and say, we do rehab here, come and pay. I mean, there's obviously quite a bit that you have to go through to even be approved and authorized to do it.
Correct.
And to be able to maintain that, so.
And I would like to add, if you don't mind, please, that the use of the property, women and children versus what we want to do is no more high density. We're not trying to be any more high density than that was approved. We're happy to comply with the existing business binding development plan and have those inspections. We're happy to do it. That's fine with us. We're just trying to figure out a way to make that happen.
And how do you feel about like an 8-foot fence as opposed to a 6-foot fence, or 8 to 10 foot? I mean, is that?
I'm okay with an 8-foot. I think that's.
I mean,
that's
and I'm
sure.
not saying it's going to get approved, I'm just saying, I just figure I
Understand.
might as well ask you while I have you up here.
That's fine, yes.
Does anybody else? Okay,
Yeah,
because
if I may.
Commissioner Pritchett was next.
Oh, okay, I'm sorry.
Thank you. Just a couple thoughts. I'm trying to get all the emotions out of this so that we can make good decisions. This facility at one time was an assisted living facility.
Yes, this facility prior to 2004 had the rights to be an assisted living facility under the AU zoning
Before we
code.
changed it.
In 2004, it was changed, brought out of that AU zoning into the new institutional zoning classification, and it was restricted to just assisted living facility use. I should also clarify that in the binding development plan that limited that zoning and that use at that time, the limitation to assisted living facility was in a whereas clause. In 2009, when it was changed to a detox, or to a dormitory, it was in a whereas clause. And today, when they propose to limit the use to just a treatment and recovery facility, they started drafting the document the same way with the limitation in a whereas clause. So, yes.
Okay, because I was thinking about the traffic first, so that would have been a little bit more traffic than what we've been seeing. I've worked in ministry for 30 years, and I've worked with like women and children's homes, and in those, you're doing treatment. You know, there's always that underlying thing that has to be done because you have women that have drug problems or they've been incarcerated, and you have them in homes now, their families won't take them. So this is really what's been going on there anyways. It might have been a dormitory situation, but you've really had that going on anyways. So I'm trying to determine, is this a different personality? Probably, no ma'am. No ma'am.
Please. You've had your chance.
Probably a little bit, but I'm not so sure it's not a little bit of an easier change here. And the reason I'm mentioning that, because up north they just built one of these facilities in our district, and it's actually working out very wonderful. Because what I'm seeing now is the people that are having problems with this, they're not bad people or evil people. They're just people that have had this drug situation. They're having a hard time getting off of it. And, you know, you're seeing 17-year-olders, you're seeing 20-year-olders, and so I think this is a very good thing, and it's not bringing out really a bad class of people. And a lot of times they have felonies because they've gotten caught by the police, and that's what's incurring them to have to get treatment or realizing they got to make changes. So as far as a change of a personality, I'm not so sure it's not a better change for the area. As far as the traffic, which I thought about a lot, I'm not so sure that it's not traffic situation that would have been there before. I do have a concern though, and I was hoping that you would consider this, or how we would consider this, that we would do an upgrade as you're doing this, because it is going to make more traffic than now because nothing's there, of maybe doing some upgrades on that connector road because it's going to get a little more traffic. Or as Commissioner Smith just mentioned, that might be something to consider, because I think that's just maybe reasonable as you're expanding the amount of people that will be there. So I think that's just reasonable, and I like that you thought that an 8-foot fence might be appropriate, because I think that's something else too that might help too. But I think, you know, I think this is actually going to increase property values for what's there now, because
Please.
I think this is going to be an excellent facility for what we have going on right now. These aren't free people. No, ma'am. These are not free people that come in. They are paying, and they're paying a lot of money from working in ministry. I've seen families that have spent $30,000 sending their kids to these. And so this is not a cheap thing to do either. So they're not going to just check in and check out, because they're going to be there trying to get this treatment. And so I get this. It's like a hospital. And on that note too, you could put a hospital in right now with the zoning, and there's nothing we could do to change that. And that's going to have a ton of traffic too, and it's going to be doing treatments. So I'm almost, you know, I don't know how to do all this with what we have going on with the BDPs. I get that, but I'm trying to figure out intent here right now as we're moving forward. And I'm not so sure that that's all that different. And that's my thought right now, unless you guys got something else that will change my thinking
Commissioner
more.
Lober.
Okay, a couple things, because I know that we've had a lot of back and forth up here. In addition to what Mr. Smith had stated, I'm happy, it sounds like you're willing to have an 8-foot fence. You're happy not to hire felons. I know you addressed earlier that you were okay adding parking as well. And then I believe Mr. Knox had mentioned that he was fine striking that 1-year, basically, grace period in the BDP, which was the most troubling thing out of all this to me, to come in compliance with Brevard County Code. So with that, I'd ask Ms. Bentley, what is the best way to accomplish this if a motion were made with respect to trying to incorporate those changes and to have that proposed?
I think it's striking 3H, I, and J, and if Mr. thinks there's another one, feel free to pitch in. And I think there was also a question about owner or developer in your discussion. I didn't know if you wanted to include that or not.
Commissioner Glover, we're not asking to be restricted from hiring felons. We're asking
Forcible
that
felons.
forcible felons.
Okay.
Which is your
Okay, I apologize.
That's a threat, just to be
Sexual
clear.
predators,
Yeah, we
your
want to be
violent
very
crimes.
careful, because in Florida, if you steal $300, you're a felon.
Or you have a driver's license suspended, you're a felon. I mean, you could be
3 times,
Yeah.
if you get picked up for that, but
I don't know, because I've never had that happen.
I haven't either, but I've seen that play.
Sure. No.
Never had it once. So that would be the way to accomplish that?
So is the applicant okay with us striking those things from the newer BDP? I believe it was striking H, I, and J. Is that correct,
Yes.
Kurt?
Yes.
And owner, developer to owner developer?
Yes, the property is under contract to be sold to my company.
Okay, and then 8 to 10 feet?
I'm happy with the 8 feet, please.
8 feet?
Yeah,
Okay.
we need it to keep people from coming in, not going out. It's a
You get a
lot of break-in attempts?
And the
No,
entrance
we
closing
don't.
too, correct?
It's
No, I
really-
mean into the facility.
No, we don't. We don't need a fence. We're
Okay.
just doing this.
I think they're gonna close
It'll be
it.
the only one where
So
we
they
have a
don't- they won't
fence
come
in
that
our whole
way.
system.
Interesting.
Yeah, it's true.
These are the things that we approved before, so strike it.
Thank you.
All right, the other thing was the 1-year provision was strike that, too.
I appreciate that. Yeah, that was concerning. I think that was H, if I recall correctly.
Okay.
Yes, it was H, I, and J.
And does that address everyone's concerns?
I think so.
Well, we still have to mention the changing the entrance to the northern.
Yeah, I said that too. I just
I
kind of
think
mumbled it.
we can guarantee you, we will apply to St. John's to get a permit to do that. I assume that we'd be able to do that, but if we can't, for some reason we can't,
Well, if it's beyond your ability to do so, but you need to try, and we need to know that
we'll
you
make
did.
a best,
And
good faith effort to do it.
I looked at the maps, and I don't think St. John's, the area there, the part of that property that would probably be affected by the St. John's would be the northeastern part. This is the northwestern, so I don't think it would be a problem.
And you want that entrance language in the BDP, correct?
Yeah.
Yeah, I think Mr. Lee has something to say about that.
Commissioner Smith, I've walked the property. We can move the entrance closer to that corner on Otter Creek you're referencing. We will do that as long as we can get it permitted. Done. That'll be done. Okay.
Are we getting all the points down?
Owner developer?
Yeah, and the H, I, and J, and the Otter Creek improvements, and the,
And the stop sign.
Anything else from the
We
planning
can
department?
do the
I
stop
think that's
sign,
it.
right, the county? John?
we can look at it probably.
Commissioners, I was trying to figure out exactly where the north entrance is and why the St. John's would be involved, and I'm not sure what the answer to that is. So if you would repeat your question?
We can put a stop sign at the end of Dixie Highway?
At the north end of it,
Yes.
you're referring to? It would require some geometric modifications, and I don't know if the regular stop sign warrant analysis would show that it was required. It certainly may. But it would require some geometric modifications to the intersection, for sure.
And that wouldn't be a part of the BDP, because that's us.
No, that would be a consequence of putting in the stop sign. If we were going to put in a stop sign, then there would be, the modifications would have to be implemented as well to go along with it. I'm not sure how extensive those would be, but I'm pretty confident we'd have to put in something in there. That street has been modified previously, actually, to make it easier to not have to stop there. And so this would be backing away from that position. I'm not saying it's good or bad. I'm just saying that's what I can recall it being different than what it is right now.
We could have traffic look at it, right, to make sure it's a good
That's
fit.
correct. We'd have to take a look at it and see what would be the appropriate thing to do.
Well, how about if we just say that if appropriate, after our study is done?
I think that would be a very acceptable way to go about it, yes.
All right, does everybody, Eden, you got all those little things in there? Okay. All right, does somebody want to make a motion?
I'll make the motion that we approve
Don't you hate
this
your weight?
application, provided that the wording has been changed to developer owner, that we strike 3H, 3I, 3J, that we have a change in ingress and egress to the northern part of the property, and that if necessary, a stop sign will be added, and that then an 8-foot fence would be required.
Is that everything?
Somebody going to second it?
I'll second it.
Second by Commissioner Lober.
Do we, Scott, do we have to add the forcible felon in there?
Please do that.
Okay. All right, we need to do that. And
So you want to amend your motion?
with the septic application, they're going to have to modify the septic to, up to our current standards, which is ATU, Advanced
Yeah.
Treatment Unit.
What's the site plan?
That would be my interpretation, or that's consistent with my recollection, how the code,
Okay.
current code would apply, yes.
Okay.
So you want to amend your motion?
Okay, let's amend the motion to include the fact that
Forcible
the
felony?
septic system has to be brought up to current standards, and that the word forcible felon would be added.
Okay, and...
I'll still second it.
Okay, that's all right. Okay, Commissioner Tobias?
Yeah, I just had a question about that last addition. I think we're only allowing non-forcible felons. Was that the final addition?
Well, yeah, but the inverse of it.
It's basically prohibiting forcible felons.
Prohibiting forcible. Okay, so my question, because someone on the board said that this potentially could raise property values. I'm not familiar with that area. I'm not familiar with real estate. But would a felon, like a drug trafficker of methamphetamines who peddled this stuff to kids, would that be an example? Because we kind of joked around, said it was someone that steals $300.
I don't think that would be a
someone-
forcible felony. I don't think that would be something that would be prohibited.
So that would be a non-forcible peddling methamphetamines, which we were told.
That doesn't strike me as a forcible felony.
So these are the, so bringing these people into this neighborhood could potentially raise property values? I'm
Yeah.
sorry on that one. I think that.
Yeah. Hold on, Commissioner Pritchett has her light on.
Yeah, sir, on that, I've been around a lot of homes where you have women and children, and it's just the difference in the facility they're bringing in here to what's been on there currently is going to drive up property values. It's going to be an improvement to the property. Now, when you have people going in treatment, they're going to have felonies. And so what this is allowing is people with the felonies for having drug problems being able to be treated on the property. And that's what the difference of that is, sir. And they add it forcible because you're going to have people with problems, but they're not going to have somebody with violent crimes now being allowed on this facility, and that is protecting the people that are going in there for treatment and the neighborhood also. I think that was the heart of the change in the binding development.
I understand, and I understand, I feel for women and children that have drug addictions, but I'm not talking about the women and children. I'm talking about the felons that peddle illegal drugs, the opioids that we were just told that 70,000 Americans are dying, kids are dying. Just to be clear, that those individuals, not the women and children that will be going there for treatment, the people that are peddling those drugs to our kids are going to allowed to be going there, and that's going to raise property value. I cannot follow that line of logic, so I will be voting no on this one.
Those ones will probably be in prison, Commissioner Tobias, because if they're peddling them, they're going to get a lot of years. But these are ones that don't have as severe of a fine that they're going to find themselves in prison. These are the ones that are being open and opted for treatment.
May I?
Oh.
With respect to
You're
that,
fine.
I'm taking my commissioner hat off and putting my attorney hat on. The mandatory minimum off the top of my head for trafficking methamphetamine is 15 years, plus a $250,000 fine. That's the minimum. It's a first-degree felony. It's not a first-degree felony punishable by life. Theoretically, you could get anywhere between 15 years and 30 years. If you were a person that had no history whatsoever, you didn't even spit in the sidewalk, to give an extreme example, and you were convicted of trafficking methamphetamine, barring exceptionally extenuating circumstances, you'd be sentenced to Department of Corrections for an absolute minimum of 15 years. So as Commissioner Pritchett mentioned, it's extremely unlikely those folks would, within any reasonable degree of time up to that point, be out and about in a treatment center. Now, after the fact, and I had a first-degree felony methamphetamine trafficking case in which I represented the defendant in December, so a month and a half ago, and we did get the mandatory minimum, but it was followed up with drug treatment after the fact. So he's going to be in Department of Corrections for 15 years, but as soon as he gets out 15 years from now, presuming he still has a problem, and whether he does or not, he's going to be in treatment. So whether he's in this facility or another facility...
Department of Correction that doesn't qualify, remember, for this facility?
Well, if it's someone who had a felony, I don't recall there being something prohibiting them from coming as a patient after the fact. We're not talking about folks that are...
I'm just trying to be funny because I'm just trying to make a point.
I'm sorry. But the other thing to keep in mind with drugs and felonies, I'm not trying to get off on a sidetrack or a tangent, it's really easy to pick up a felony with respect to drugs. The only drug, so to speak, that is oftentimes a misdemeanor is possession of cannabis or some form of THC. But if you have any amount of methamphetamine, if you have a molecule of methamphetamine, that's a felony. And what's more, and this was the case with the one that I referenced a moment ago in December, if you have a molecule of methamphetamine or some small amount of methamphetamine in a mixture of anything else, it can be a swimming pool, they're going to charge you based on the weight of the pool. So it's something where it's really easy to get charged with a serious felony despite having only an amount potentially that's for personal use or for you and your buddies that are doing what they shouldn't be doing.
Quick question. I'm guessing you were a defense attorney and not a prosecuting one. Is that a fair assessment?
I plead the fifth.
Commissioner Smith?
Yes, I want to make clear that some question was raised about the aerobic treatment unit. So I want to specifically put in the motion that the septic system that they install will have an aerobic treatment unit that will reduce nitrogen and phosphorus from entering into the groundwater.
Is that acceptable? I guess it's got to be acceptable to the applicant.
That's our current code. But I
I was
just
going
want
to
to make
say,
sure that...
well, then they're required to anyway, so it doesn't need to be in there.
We'll put whatever is required in.
Right. Well, I just want to make sure that we understand that that's required.
Yeah.
I believe staff's concern on this was whether or not it would be required. So while it might be required, we weren't sure if the intent was that as part of the binding development plan, there was an agreement that it would be upgraded so that it would have that. That's really what staff was interested in making sure we were clear on.
That's not a problem upgrading it.
Yeah, I'll keep the
So
second.
are you amending that? Okay.
Yeah.
To include that? Has everybody got that? I don't know how the clerk and the attorney are keeping up. And you agreed to this?
Yes, I'm fine still seconding it.
All right, I'm going to call the question after I'm done saying this. You know, I won't repeat a lot of the stuff that Commissioner Lober said, but to assume that a drug dealer is going to go want to hang out at a drug treatment facility is about as ridiculous as all hell. I mean, our crisis in our communities, and less to do with whether or not we approve this, and it looks like it probably will be approved, is it's more opioids than it is anything else. It's not your hardcore drug dealing, gang banging type of person that's going to seek treatment through his insurance company or privately at a fancy or at a private facility, a voluntary private facility, not one that's mandated by a court or forced to be there. And that's what I really like about this place. It's not somewhere that you have to go, it's somewhere that you want to go. So I think you're going to do everything you can to make this nice, because if you don't, I'm sure we're going to hear about it. So I will support
Madam
this.
Chair,
'cause-
I have a question from staff over here. I hate to interrupt, but there are some conditions in the binding development plan that we either didn't strike today or didn't repeat out loud. So I just have some confusion about whether or not those are to stay or to go. There's a condition about, I think we struck several of them, but there's the proposal about not contracting with the jail or prisons, G, the developer shall limit the occupancy of the building to 47 residents. That just wasn't reiterated in your motion or clarified if it was struck. And then there's the square footage limitation that was proposed in the binding development plan. So we just need some clarity.
I believe that we approved the binding development plan as it was written, minus H, I, and J.
Minus the 3, and then plus the things you added.
Correct.
Okay, thank you.
So I'm going to call the question, if that's all right. All those in favor say aye.
Aye.
Any opposed?
Nay.
Motion passes 4-1.
What restricts business when you've already got stuff?
It's not a pre-existing business. There's nothing there.
I gotta give you a hard time.
Okay, I have no public comment cards, so I'm going to go to board reports. Mr. Bate?
No reports?
Ms. Bentley?
No report?
Commissioner Pritchett? No reports. Commissioner Blober?
No report tonight.
Commissioner Tobias?
No report.
Commissioner Smith?
No report.
And I have no report. So with that, I'll call this meeting adjourned.
I know.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.